The Subcommittee on Interior, Energy, and the Environment will come to order. Without objection, the Chair is authorized to declare recess at any time. I appreciate everyone being here with us today. Good afternoon. The Subcommittee on Interior, Energy, and Environment is meeting today to answer calls from farmers, ranchers, and rural communities to address the problems generated by special interest environmental litigation and statutes that incentivize it. During previous hearings, the subcommittee has heard from a number of witnesses across the country who have described how the court system has been used to restrict access to federal land, obstruct infrastructure development, and stifle responsible use of our natural resources. Unfortunately, many Montanans are already familiar with this problem. Serial plaintiffs and special interest groups have used litigation to threaten our Montana way of life by thwarting efforts at responsible forest management despite the threat of catastrophic wildfires, and deny our communities access to surrounding resources. For example, the critical Lower Yellowstone irrigation project almost fell victim to such extremist litigation. Over a decade ago, Congress authorized improvements to the Lower Yellowstone project, which serve 400 family farms as they rely on it for their source of water, and over 50,000 acres of cropland. However, this did not stop special interest organizations from filing suit against the diversion dam and a bypass channel designed specifically for the pallid sturgeon, repeatedly delaying the project. Fortunately, after a legal battle that reached the United States Court of Appeals for the Ninth Circuit, a district court judge allowed the project to move forward. During this delay, I worked with my colleagues in Montana and North Dakota to keep the Army Corps of Engineers and the Bureau of Reclamation moving on this critical project. Additionally, I joined Representative Jason Smith in offering an amendment to the FY19 Interior Appropriations Bill to block the sue and settle practice under the Clean Air Act, the Clean Water Act, or Endangered Species Act. Our amendment was adopted as part of the House bill, and we're waiting on Senate action. Having heard the impact of environmental litigation at our previous hearings, we will focus our attention today on additional opportunities for reform. We will pinpoint provisions of our environmental laws that are vulnerable to misuse and stages of the legal process that can be manipulated by special interests. We will also learn more about fee-shifting statutes that reward litigious organizations for suing to oppose federal agencies' missions with which they fundamentally disagree. In particular, many Montanans have shared with me their concerns about the abuse of the Equal Access to Justice Act. Congress passed EJA to enable small businesses and individuals to challenge wrongful government action despite a disparity in resources. It's an important tool to ensure Americans receive Social Security benefits and Veteran Administration benefits they deserve. Today, however, wealthy environmental organizations take advantage of the law's loopholes and exemptions to obtain large fee awards from our federal agencies. In these cases, this is an abuse of taxpayer dollars, and it's a burden on agencies that are already devoting considerable resources to guarding against and responding to litigation. By more closely examining EJA, as well as the way courts have interpreted it, I hope we can identify reforms that minimize the potential for misuse while preserving access to our court system when the government does make a mistake. I want to thank our witnesses for their time today and for their contribution to this conversation on this important topic. In particular, I'd like to thank Commissioner Mark Peck and the rest of the Lincoln County, Montana Board of Commissioners. Commissioner Peck had planned on being here today, but was unable to make it due to an illness. I appreciate his willingness to travel across the country to participate in the hearing, and will include his written testimony as part of the hearing record. Commissioner Peck and the other residents of Lincoln County have personally experienced how special interest litigation can halt forest management efforts and those that enjoy support, even those that enjoy support from many stakeholders. Lincoln County contains a significant amount of national forest land, and special interest litigation in such communities can be a tremendous obstacle to economic prosperity and a threat to public safety. I look forward to continue my work with the Lincoln County Commissioners and the people of Lincoln County on this issue and in the future. Thank you all again for being here, and I look forward to a great discussion. At this time, I'd like to recognize